Loud. We're going to share the screen. The keynote share. Okay, and let's play. Okay, so here is the, oh, I gotta swap these back, I think. This thing drives me crazy because it's like it's not the way it's supposed to be. Let me do this. Oh, I gotta swap it over this way, that's why. Okay, there we go. Understanding the Florida real estate contract. Okay, so 73% of all home sellers who said they are more likely to list their home with a real estate agent who uses video in their marketing. I just thought that was a very interesting perspective. So just wanted to throw that out there. Does it really mean anything? But just thought it was kind of cool. So do you know the different sections of your contract? There are, we discussed them in the first part, where there are all the different sections. You need to be comfortable enough where you can go through them. Of course, the first one is the property description. The second one is the price and closing. Third one is the financing section. Then the parts we're going to get to today: property maintenance, condition inspections, and examinations, as well as closing costs, fees, and charges. Then you have disclosures, escrow agent and broker, default and dispute resolutions, the standards of the contract or the terms of the contract are built on, and then of course you have your addendum, additional terms, and then the additional terms for the contract. So today we are going to go over the section starting in on page, I'm out of order here, sorry, page 4, I'm sorry, page 3, the closing cost, fees, and charges. But before we get that, let's just go over review really quickly what we covered. Is that the 6 things to know about a contract. We talked about how it has time constraints, it's amendable, etc. You can go back and watch the video for that. The 11 sections of a purchase contract, we just talked about that. The first video, we talked about the property description, the purchase price and closing, and the financing. And I always stress this, the contract is very, very important to know. It is the backbone of what we do, so you need to know it inside and out. And today, you're going to be shocked because there's a couple of things in the contract which I guarantee you're not doing or you didn't know because you didn't read it closely. And we're going to discuss those today, and it's probably going to change the way you do business a little bit. So let's keep going. Again, we're using the as-is contract because that's the contract that we use in our area right now. It's the same pretty much as the FAR bar regular purchase contract, but there are some differences, and one of those will be discussed today. So let's talk section 9, fees and charges. We're going to start with closing costs, fees, and charges. These are all the costs to be paid by the seller and costs paid by the buyer. So there's certain line items in the contract that need to be checked in order to dictate which party is paying for which cost. So for example, if you look at costs to be paid by the buyer, and there's a municipal lien search, owner's policy premium, those are the things to choose if the seller or the buyer is, and we'll come to that in a minute, but if the buyer is going to choose the title company, then they're going to be responsible for the lien search and the owner's policy premium. So that's why they have those caveats if paragraph 9C is checked. Okay. Another thing that you need to notice under costs to be paid by the seller is on 132 to 135. If prior to closing, the seller is unable to meet the as-is maintenance requirement, which we'll talk about in paragraph 11, a sum equal to 125% of the estimated cost to meet the maintenance requirement shall be escrowed at closing. If actual cost to the as-is maintenance requirement exceed that amount, the seller shall be paid such actual costs. Any unused portion of escrowed amount shall be returned to the seller. We're going to go over that in a few minutes, what that means, but that's a very important part, and it ties into the maintenance requirements of the contract. So dog stamps on the deed, that's cost to be paid by the seller, as well as owner's policy charges if the owner is chosen, title search charges, municipal lien search charges, HOA and condo fees are always responsible to the seller. Recording and other fees needed to cure the title are always paid by the seller, and any seller's attorney's fees. If there are other items, then the cost will be paid by sellers. Some people will put if the buyer is asking for closing cost concessions, you may find it in that section where it says seller to contribute 3% towards buyer's closing costs. They'll either put it there or they'll put it in section 20, but sometimes you'll find it there. Cost to be paid by the buyer. This is important to go over with the buyer. They're responsible for any taxes and recording fees on the notes and the mortgages. Also for any recording fees for the deeds and financing statements. That's to record the mortgages. If they choose the title company, they're responsible for the owner's policy charge. They're responsible for the survey and EC, the elevation certificate, if required. They're responsible for anything to do with lender. Any association, application, or transfer fees, the buyer is responsible for paying as well. The transfer fees get people sometimes, but they're there. Obviously, the lien search, if they choose the title company, they're responsible for loan expenses, appraisal fees, inspections, attorney fees, and all property-related insurance, meaning after the fact that any policies. Sometimes there may be other items that you're aware of. You need to make sure you write those in and negotiate them prior to executing an offer. So let's keep moving. Now we're going to go to the next section, which is title evidence. And this can get a little confusing because it's a little wordy. So let me recap it. The seller has up to the 15 days prior to closing, or whatever number of days that are written in, unless paragraph 8A is checked, which is the financing that they'll pay cash. The seller has up to 15 days prior to closing to obtain and deliver a title insurance commitment. And after closing, they have to provide an owner's policy of title insurance. Now, what does this mean? For you, if you represent a seller, if the title company does not get a title insurance commitment within 15 days prior to closing, the seller is actually in default of the contract. The buyer can walk away. Okay. If the seller already has a title insurance policy in place, let's just say they sold it from a couple days ago and they already have a policy in place, they have 5 days after execution to deliver it to the buyer and title because it can be reused. That may be a question you ask. Do you have an existing owner's title policy? We need to see that. The buyers and sellers, that's the top part. It's not really, you need to read through it and understand it, but it's not necessarily something that you have to enforce all the time. This is hardly ever enforced, but it really should be. Also, there's a caveat on there, line 154, for purposes of this contract, a municipal lien search means a search of records necessary for the owner's policy of title insurance to be issued without exception for unrecorded liens. That's what you're looking for. So that's what a municipal lien search is. The seller and buyer designating who chooses title. There are times, for example, let's say that you represent the seller on the sale of a home and they're going to buy a new home. If they need the proceeds and do a simultaneous close, that may be the time that a seller or buyer wants to pay for the owner's title policy and choose title, so the same title company is doing the closing. You can negotiate with the title company on some of the fees. The owner's title policy is pretty much dictated, not going to change much. But the payoff to the buyer is that the same title company is doing all the work and everything's together and they're kind of moving simultaneously versus two separate entities. So there are times when you'll choose that, but you need to choose that during negotiations. Great part. We have line 164 to 169. Unless you're writing something in Miami-Dade or Broward County, you don't need to include this. If you are writing an offer for something down that way, you need to let us know. We'll get you to an attorney or title company who can help you choose and decide what to do with this part. So let's move on to section 9. We're still in the closing costs. Now we're in the survey, which is D. And this is kind of important. There are some important caveats in this. During the negotiations, the buyer should always inquire if the seller has a survey. If the seller says, yes, they do, you need to get that positive response in writing, whether by email or on an addendum, whatever it may be. As this then triggers the second part of this section, which says the seller has 5 days after the effective date to provide the survey to the buyer and the closing agent, to the title company. If they don't do that, then they are breach of the terms and the buyer can cancel the contract if they wish. Even if you have 0 inspection days, if the seller says they have a survey and they don't provide it within 5 days, the buyer has the right to cancel. Also, on or before the title evidence date, which is from page 3, line 145, the buyer can have the property surveyed. This does not mean ordered, but actually completed. That's where we're going wrong as well. After the title evidence deadline, the buyer cannot back out of the contract if there's a survey issue. It's very clear right there. On or before title evidence deadline, the buyer may, at buyer's expense, have the real property surveyed and certified by a registered Florida surveyor. So again, that's something we're doing wrong. I know a lot of surveys are ordered right before closing. You need to make sure that as soon as you go under contract, there's some things we need to change. You really need to order your appraisal and your survey right away. I get that they're expenses to the buyer, but that's part of the deal. They're making, if you go past that date and there's a survey issue, the seller has no obligation to fix it in order for the deal to go through. So remember, whatever that date is, and as we said before, it's defaulted to 15 days prior to closing. So if you have a 30-day closing and you leave that 15 days as the blank standard for the title evidence date, you have 15 days then to get your survey done. Something we probably need to be thinking about. Also important, the survey has to be completed by a certified and registered, meaning licensed surveyor. Next section, the home warranty. This is an item that is negotiated prior to execution. If you're adding a home warranty after execution, don't go back in and add this to the section. You have to do it on a blank addendum. Once you execute, if there's nothing filled in here or it's checked in, it's got to stay that way the entire time you add it on to an addendum. Very important, don't just decide on a price, but decide on a company as well and put it in writing. We're using American Home Shield, and the seller's going to pay $600 towards that home warranty. The buyer also still has the option to add to the coverage or just add coverage if they want to at their expense. All right. Now, even if the buyer is going to be expensing it, you still want to put this in the negotiation. Buyer's paying for a home warranty, and then put that number in this section. Do not, under any circumstances, discuss what a home warranty covers. You can't say, oh, if it fixes your AC if it's broken, if your appliances are broken, it fixes it. Don't say that at all. A home warranty covers certain items on your home. Here's the contact to home warranty company A, B, C. You need to call them and find out exactly what's covered on the policies that you want, what the terms are, the deductibles are, and how much they are. Let me put that in your hand. Don't, because again, you're just setting yourself up for an errors and omissions claim, or you could be buying a new refrigerator if you don't say it right, or AC. So again, don't ever make the assumption that it covers something. Just say, hey, a home warranty is designed to protect the systems and help you, just as it is an extended warranty. Let me get that information to you, and you can discuss with the home warranty company. If you represent the seller, this is discussed in section 2 of the SandPeak Addendum Listing Agreement. It actually asks them if they're going to provide a home warranty. Make sure you show the sellers where this is coming into play. So if you're talking about that section during your listing agreement and you're saying, the reason why I'm asking this question is because when a contract comes in on page 4, line 173, it specifically asks if there's a home warranty included. So we're having this discussion now, so we're aware of what to do during negotiations. So it makes you just look a lot better if you do that. Special assessments, another part that gets really confusing for people. What this section states is that the seller shall pay the full amount of any liens that are imposed and confirmed, certified, and ratified before the closing dates, not the execution date, before the closing date. And that those amounts are based upon the most recent estimate or assessment for an improvement that is completed as of the effective date. So there's 2 parts to that, but that has not resulted in a lien being imposed, should be say imposed, not imposted, imposed prior to closing. What does that mean? Let's take a paving assessment. That's one that you may see. If the repair is completed prior to execution and it's been ratified and the amounts are certified, but the actual lien has not been put in place in the county to the homeowners, then the seller is fully responsible for all payments of that lien. Okay. Now, if the lien is already in place and it's, and we're going to talk about that in a minute, it's being paid in installments, then that's where the second part of this comes through. And that's the part that confuses people. Again, if the repair is completed and it's ratified and certified and that the estimate is out, but the lien has not been put in place, then the seller is responsible for paying that full estimate or assessment. Okay. We'll come back to the second part about the installments in just a moment. The buyer is responsible for all other assessments, meaning these are the ones that are confirmed and certified, but not yet completed. We're going to add a paving assessment, but the work hasn't been done yet. Well, from the moment you take that property over, right, and the work is starting, you're responsible as the new homeowner. Why? Because there are times when things go into place and then they back the project out. So that's why that's in place that way. So again, repair is done, lien is in place, but it hasn't been filed yet, seller. Work isn't done, about to start, or is just starting, but nothing's in place, buyer, period. If they can be paid in installments, you have the choice to choose either the seller to pay the installments due prior to closing, a buyer shall pay all installments due after closings, or the seller shall pay the assessment in full. If neither box is checked, it defaults to A. And that's pretty much the one that you're going to use. It's very difficult as a negotiating item to convince a seller to pay all the assessment in full. So just keep that in mind, it defaults. If paragraph 9F shall not apply to a special benefit tax lien imposed by a CDD. So if it's in a CDD community and there's a special lien associated with that, that does not apply to this section, okay? Now, again, you can negotiate for the seller to pay the assessment in full, but again, it's all things as negotiation. Okay. Now we're moving to disclosure. And you know how I all feel about a disclosure. Disclose, disclose, disclose. First disclosure, we live in Florida. There's this thing called radon, which naturally exists here. You need to make sure when you're going over the contract with your customer that you read this entire section to them. Mr. Buyer, radon is a naturally occurring radioactive gas that, when it is accumulated in a building in sufficient quantities, may present health risks to persons who are exposed to it over time. Levels of radon that exceed federal and state guidelines have been found in buildings in Florida. Additional information regarding radon and radon testing may be obtained from your county health department. If you would like to have a radon test done on this property, you may do so, but at your expense. Bang, okay? And they have to get that done within the inspection period. Permits, another confusing part. Okay. On the seller's disclosures, they have a section that they can disclose any open permits that they're aware of. If the seller does not state in a written disclosure any improvements that they are aware of without required permits, and one is discovered prior to the close of escrow by the buyer, then the seller is default and the buyer may cancel. So let me explain that again. There's a shed out back. It's attached to the side of the building. It's got a concrete slab. Seller's like, oh, we didn't need a permit. We just built it, whatever. Okay, great. They didn't disclose it on the seller's disclosure. Go through the inspection process, no problem. Go through the lien search. All of a sudden, it pops up that there is an open violation for a building code on this property because it wasn't permitted properly. We're 2 days before closing. At that point in time, the seller is in default. And the buyer can say, you had an opportunity based on section B here on page 4, 195 to tell me about this and you didn't. You're in default. I can walk away from this contract if I want to. You most likely negotiate that, but again, it's here in writing. Now, If the seller discloses in writing that they're aware that they built this and it's an open permit and it may, or that it's not permitted, and the seller's aware of that issue, or I'm sorry, the buyer is aware of that issue, then they can't do anything about it because they've been made aware of it as part of the negotiation. If the seller identifies such improvements, they have a duty, is what it should say, not to have a date. They have a duty to provide promptly all plans and information to the buyer, meaning anything related to the plans, anything related to the building department. Promptly, in legal terms, I looked this up, generally means as soon as possible or within 2 business days. And that's important because there's several times throughout the contract that the word promptly is used. So again, what does this mean? If you are reading the seller's disclosures and they say, we're aware that the garage was done unpermitted. Well, you have to provide all documentation regarding that unpermitted, whether it's plans, any emails back and forth with, or forms filled with the building department, whatever it may be, estimates related to that issue. My suggestion is if you're reading through these documents, the seller's disclosures, and you notice that there's unpermitted items, don't execute it until you get that negotiated and worked out. Try and work it out up front versus after the negotiations. Mold. This is what I say about mold. It's Florida. It's wet. It's humid. It rains a lot. Mold naturally occurs. Okay. The buyer has a right to a mold inspection to be done if they choose within the inspection time period, and that they have to do it at their own expense. The seller does have a duty to disclose all they know on the seller's property disclosure about molds. Pretty simple. That's why it's only 2 lines. Flood zone. Now, this is, again, another tricky issue. Again, this is one of these ones where we're probably doing this wrong, and we need to make sure that we're following the contract correctly. First of all, it's the buyer's responsibility to verify the elevation and determine if flood insurance is required by their lender. I always like to ask on a property that's in a flood zone, does the seller have an elevation certificate? If they say yes, they have a duty to provide that to you. That's part of the survey. That goes to that whole survey thing where they have 5 days to get it to you. Same kind of thing. Elevation certificate falls under that category. Okay. It's the buyer's responsibility to find out not only if they need flood insurance, but if it's required by their lender. And that's something you need to do right away when you go under contract. If the property is in a special flood hazard area, which just means it's in a flood zone, or coastal barrier resources area, and the lowest floor elevation is below the minimum floor elevation, right? So this is the minimum and this is the lowest, or it's the property is ineligible for flood insurance, the buyer may terminate the contract up to an agreed upon period after effective date. It's right here on line 210. Buyer may terminate this. Oh, wait, let me go back. That's all right. We'll come back to that in a second. Buyer may terminate. Okay. That's very important because I want to go back to it. That's a very important one. Let's see here. Let me come back here. Let's play it again. Buyer may terminate the contract up to an agreed upon period after effective date. Most people leave this blank at 20 days. My suggestion is to leave this, get it up to 5 days prior to closing. That gives you some time to negotiate that. So don't just leave it blank. Put it 5 days before closing. That way you have time to get your buyer out of this if they need to. And they have to do it in writing, of course. But if the buyer accepts the findings of the elevation certificate comes back, they find out that the base elevation is lower than the flood elevation, and they accept the findings, then this all goes away. They can't cancel. Okay, so very important. This also lets the buyers know that rates can change in flood insurance. So we talk about this on the SandPeak addendum to contract. That's why I bring it up there, so it's a talking point that you can talk to about your sellers and your buyers. You don't want the surprises at the end. The important part about this is that line 210 with that date to cancel. Energy brochure. This contract, when you read this, infers that the seller is providing an energy brochure to the buyer. Now, that generally means that we as agents are responsible for providing that. We're not doing that. We need to figure out a system to do that because technically in the contract, we're supposed to provide an energy efficiency rating information brochure. I'm going to look at that as the broker. We're going to get that figured out. It'd be kind of nice if there's some way we could automate that where an email goes out to the buyer, but we'll figure that out. Next one, lead-based paint. This disclosure obviously alerts all parties that the property is built prior to 1970. It is a residential housing unit, condo, townhome, duplex, triplex, single family attached, single family detached, whatever it may be. Then a lead-based paint disclosure is mandatory, not optional. It is mandatory. It has to become part of the contract. The seller and the seller's agent always provide this. If there is not one in the MLS system, in the attachments, or it's not made available to the buyer prior to the contract negotiations, do not proceed. You are breaking the contract law if you proceed. They have to provide one. If they don't want to provide one, then you need to go up the ladder to their broker and explain that per the contract, they're supposed to provide one. If they still don't want to do one, then you have to negotiate that and talk with your buyer and see if they want to proceed. Don't ever complete a blank lead-based paint addendum, have the buyer sign it and send it to the seller to fill in, because that's dangerous. It's always got to be the other way. The seller completes it, signs it, and sends it to the buyer. Homeowners Association. This notice also states that the buyer should not it's mandatory, but should not execute until they have received and read the HOA disclosure. Again, this is something that should come from the seller and the selling agent. It should be in the MLS, HOA disclosure. The hard part is if you go into the MLS in any neighborhood at any point in time and you click on 12 properties, it seems that every single HOA disclosure is completely different. Once you get the disclosure, my recommendation is that you verify it. You contact the association and you verify that information. If you are the listing agent and you work for SandPeak Realty, you better darn well be calling that association and verifying that information before you put it out there. This is not the HOA documents. Don't let your buyers get confused by that. This is just the addendum B disclosure. If the buyer wants the HOA documents, then they need to do that during negotiations. Okay, you can't sign everything and then go a week later say, oh, well, we want the HOA docs and we're not proceeding. It doesn't work that way. That's all. This is also addressed at the SandPeak addendum to contract. So that way it's negotiated at the time of contract. Again, this is why I've added those things on the extra addendum to help you negotiate the deals a little better. The property tax disclosure, yet another disclosure that you should read completely to the buyer. Mr. and Mrs. Buyer, the buyer should not rely on the seller's current property taxes as the amount of property taxes that the buyer may be obligated to pay in the years subsequent to purchase. A change of ownership or property improvements triggers a reassessment of the property that could result in higher property taxes. If you have any questions regarding valuation for tax purposes, you need to contact the county property appraiser's office for information. Let me give you that information. You also want to go to the property appraisers and the tax collector's website and verify that information and present that to the buyer so that they can know what they're getting into. Don't discuss values. Don't say, oh, well, you know, they assess it generally at 60% of value or 40% of value, or they'll reassess it and then you can't increase it, blah, blah, blah. Nothing. They need to go to the property appraiser for any information about taxes. Okay, you're not an attorney, you're not an accountant, you're not a property appraiser. That's their job. Send it over to them. You can discuss homestead exemption in general. I would suggest you send them to the property appraisers or the tax collector's website to understand home exemption. You could say, you know, you do get a home exemption of $25,000 for single, $50,000 for married. If you're a veteran, you get another $25,000. It takes that off of your tax assessed value. But again, refer them to the tax collector. FIRPTA. If you get a FIRPTA client, meaning a buyer or seller who's forward, there are some complications. You need some help with this. All right. My recommendation is get a title company that has dealt with FIRPTA deals, and most of them have, but make sure that the title officer is aware of it. It's best to have a title company that has an attorney on staff. The seller has an obligation to inform the buyer in writing if they fall under the FERPTA guidelines. Very important. It says that sellers shall inform, not may inform or should inform, but shall, meaning they have to do it. Again, recommended to seek legal counsel if you need this. If you represent a seller, get them in front of legal counsel before you put it on the market. You will use later down when we go over the standards of the contract, standard V or standard 5 further explains the information pertaining to FERPTA. Seller's disclosures. Okay, now we're into the seller's disclosures. Please note that written disclosures are not a requirement for execution of a contract. They are not. It's up to the buyer. Buyer beware. It does state, however, the seller knows of no facts material affecting the value of the real property which are not readily observable and which have not been disclosed to buyer. So basically that means if you buy a home and the seller was aware that there was a sinkhole claim made on the property, but they don't disclose that, that's okay in the sense of buyer beware. However, they have an obligation to state any material facts. They can be sued. So if it comes back and that they knew about it, they could be sued in a court of law. So the seller's making the statement that they know of no facts that will affect the value. This is also the section that protects the sellers from anything they are not aware of prior to them owning the property. That's an important part. Except it says, except as provided for in the preceding sentence, seller extends and intends no warranty and makes no representation of any type, either express or implied, as to the physical condition or the history of the property. Meaning, they're not responsible for what happened from the owner prior to them or the owner before that or the owner before that. They're only responsible for materially fact known what they knew going into the property and what occurred while they owned the property, okay? Caveat, you'll get investors who say, I never occupied the property, I don't know anything about it. Well, this is not about occupying the property. This is about knowing what's occurred to the property, and you've owned the property. So if you've changed the hot water heater, you need to let me know. If there was a leak, you need to let me know. If you changed the roof, you need to let me know. Anything that will materially affect the property. It also states in this section that the seller is not aware of any notice from any governmental agency about building, environmental, or safety code violations. So if during the course of the transaction, during the lien search, it comes up that there was a building code violation or a safety violation and it wasn't disclosed to the buyer has the right to cancel the contract right then and there because the seller is in default because of this section, okay? So make sure that the sellers are, again, stress to your sellers, disclose, 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 disclose. We don't want any issues or surprises later. Okay, so now we're going to go into section 11 and 12, the property maintenance, condition, inspections, and examinations. This gets tricky as well. Section 11, maintenance. This is where it gets different from the FAR bar contract, okay? This is an as-is maintenance requirement, as we call it. The seller has an obligation to maintain the property, both inside and outside, to the condition that it was in on the day of execution. So always remind your sellers that when they go under contract, they have to take care of the lawn, all the shrubs and trees and plants, and the pool. Those are specifically called out here. They're also responsible for making sure that the property is in the same condition inside when they leave as it is when it goes under contract, okay? So if the AC goes out between the time they execute and the time that they go, that they're going to close escrow, that AC needs to be in the same working condition. Doesn't mean it needs to be replaced, but it needs to be in working condition as it was during the inspections and the execution. Same with the hot water heater, same with appliances, same with flooring. Let's say you have a water leak and the floors get damaged, or the dog pees on the carpet. Well, that carpet now is not in the same condition. So those are things that you need to be aware of and address, okay? Again, this section differs from the FAR bar contract. We'll discuss that at a later date. What this is known as, and this is referenced several times with the contract, is the as-is maintenance requirement, okay? Very important to know. And it's a term that you should know and say when you're explaining it to your customers. There may be some discrepancies in the condition of a property, I said, after all of the personal property is removed by the seller. Good example of this is that the living room or the bedroom has carpet. There was a bed in the middle of the room. They pulled all the furniture out, and there's a big stain and a tear in the carpet where like a dog or something had done. How do you handle that? Not sure. Pictures can help your cause, but that's probably something you should address during home inspection. You should be looking under the beds and moving furniture. You have the right to do that. That's going to be a very tricky situation. And I've had it happen to me where you're a day of closing trying to negotiate carpet costs. Who's going to replace the carpet now that we know there's this big hole in the middle of it that we weren't aware of. So just notice that that's part of the as-is maintenance requirement. All right, let's get into inspections. And this is probably the biggest shock that I saw. And I just, again, as I was preparing this, I read this last night and I was like, oh man. I went and did a lot of research online, and I think this is something that we've been kind of doing wrong. The buyer has X number of days after the effective date to complete their inspection, okay? So you obviously want to give the buyer the most amount of time, but a seller's more likely to accept a 7 or 10 day inspection period versus a 15-day because they're keeping it off the market for that much longer. Okay? The buyer can have any inspections they desire during this time: roof, home inspection, termite, radon, mold, lead-based paint, HVAC, electrical, plumbing, whatever they want, okay? However, and it states very clearly in here that they have to pay for it promptly. It's right here on, it is section, here it is. It's on line 255 and 256. Buyers shall be responsible for prompt payments for such inspections. Again, the word prompt, now second time it's been used. For repair of damage to and restoration of the property resulting from such inspections. We'll say in a moment what that means. But again, what does prompt means? As soon as possible or within 2 business days. Make sure your seller or your buyer understands that. That's very, very important. The second time the word prompt has been used. The buyer can terminate this contract at their sole discretion for any reason. It says it very clearly. If 251, if buyer determines in buyer's sole discretion that the property is not acceptable to the buyer may terminate this contract. There it is right there. If you represent a seller, you can ask the buyer's agent, why are they canceling? They don't have to give you a reason. They don't have to provide any documentation. They don't provide anything. It's just my sole discretion. Don't like it, I'm moving on, okay? The buyer is responsible for any damage from these inspections. And we've had this happen. John had that happen with the townhome over in West Chase, right? The buyer is responsible for the cost of the inspections and to restore the property to its condition as it was at execution if there was damage. And they have to provide the seller's written receipts to show that those repairs were done. It says it right here again, line 257, shall provide seller with paid receipts for all work done on the property, okay? And this preceding provision shall survive the termination of this contract. So just because a seller, let's just say there's damage to a door. Door's been pulled off its hinges, right? And the seller's like, hey, your inspector messed this up. The buyer's gonna go, well, it wasn't my fault. It was the seller's fault, or the inspector's fault. The seller's gonna say, no, you hired the inspector. He's not party to me. You are. This contract is between me and you. And it very clearly states that you as the buyer are responsible for that repair, okay? Well, forget it, we're canceling, we're blowing it up. It doesn't matter if you cancel. Once we can cancel, but you as the buyer are still responsible for this repair. You don't want to do it, that's fine. I can sue you for non-performance for the contract. So just remember that. Okay. Once the inspection period is done, This is where we're going to get into the caveats of it. Once the inspection period is done, the buyer accepts the physical condition of the property and any violations unless they exercise the right to terminate. Very clearly, if buyer timely terminates this contract, the deposit shall be paid. However, buyer shall be responsible. Now let's go to line 258. Unless the buyer exercises the right to terminate that is granted herein in this section, buyer accepts the physical condition of the property and any violation of governmental, building, environmental, and safety codes, restrictions, or requirements, but subject to the seller's continuing as-is maintenance requirement. And there's another part to that, that's the but. Let's explain what I just talked about. Inspection period is done, okay? At that point in time, the buyer says, I've done all my inspections, I'm moving forward, I accept the property as it is. If there are building code violations on it, guess what that means? Sorry, you accepted it. We're past the inspection period, okay? You have to be very careful with these. These terms and these in the contract go hand in hand. So this really needs to coincide with the lien search, the survey, and the appraisal, all within the inspection period. This is where we're going wrong. All these items should really be done in the inspection period because you're not allowing your buyer enough time to negotiate what they need to negotiate on the contract and make sure that the seller's completing its obligations. They kind of fit together like a big puzzle. A little confusing, I get that. Okay? Here's the last part, and this is the caveat, and this is the part where I think we're all going wrong. The buyer is responsible for any and all repairs and improvements required by the buyer's lender. What? Read it right there. Line 261 and 262. Buyer shall be responsible for any and all repairs and improvements that are required by the buyer's lender. What? So what does this mean? You better have your appraisal, your home inspection, your termite inspection, and your 4-point inspection done prior to the expiration of this inspection period. Because if not, and it comes out, the appraisal, that the lender needs certain things to be done, you could get into a real gray area because the seller could say, not going to happen. Per section 12, line 261 and 262, you're responsible for that roof that doesn't go on that roof. You got to inspect it. You knew it was a bad roof. So that's on you. Yeah, but I can't get the financing then because it's an appraisal contingency and I can cancel under the financing. Well, not technically, because it says very clearly here, you buyers shall be, not maybe or should be, but shall be responsible. So if you can't get the financing because you don't make those repairs, that's on you for not being able to get the financing, not me. See that part? That opened my eyes, and I did a lot of Google searching last night across the Florida, and guess what, guys? This is the way it's supposed to be. We need to really look at how we're doing our contracts, and we're going to spend more time on that, but you really need to understand this section. That line jumped out at me like red light, red light, red light. Buyer's responsible for any and all repairs and improvements required by the buyer's lender. We'll come back to that later. Section 12, the walkthrough. Buyer has the right to perform a walkthrough inspection of the property, and the purpose solely is to confirm that the personal property has been removed, and this includes trash, and it says it in here. We'll go over that a little bit. And that the as-is maintenance requirement, as we talked about earlier, of the seller has been maintained, and that the seller's met all their contractual agreements, of course. If there's an issue and it needs to be resolved, then the buyer has a right to do a follow-up walkthrough. Okay, so you can do multiples. Let your buyer know, though, way up front, the buyer cannot bring up issues not related to the removal of trash or personal items and or the as-is maintenance requirements. It's too late at that point. Oh, I didn't notice that there was buckling floors in the corner. Well, you should have noticed that, and your inspector should have noticed it. It's too late. We can't negotiate that. You've accepted the property based upon the property inspection period as it is in the general condition. We're moving forward. Now, the walkthrough does not have to be the buyer. It can be a representative. However, you represent the buyer, but not for this purpose. For SandPeak, for us, You cannot do the walkthrough. They need to either do it themselves or have another representative do it for them. They can pay somebody. I don't care. But that person needs to sign off, because if you do it and sign off and there's an issue, it becomes a legal issue. So SandPeak policy, you cannot complete the final walkthrough for the buyer. Their representative has to. Always get a final walkthrough form signed by the buyer. And this issue is also part of the SandPeak addendum to contract. We talk about that again. It's that important. Permits. We're back to the permit section. We've already talked about the permit section earlier. Now we're back to it again. If during inspections, the buyer identifies open or needed permits, then the seller shall deliver all knowledge and documents related to those improvements. Well, if they knew about it, they had this stuff, they should have delivered it anyways. So it doesn't really make sense, this part, but it is what it is. The seller also has an obligation to cooperate in good faith with trying to get estimates to resolve such permit issues. This means letting contractors in, building inspectors in. It also includes that they have to sign any forms that the building department may need. Whatever it may be, they have an obligation to help the buyer cure that cause. However, they don't have an obligation to expend any money. It's not the cost, it's not to be paid for by the seller. This is a cost solely on the buyer. It's as is contract. Very confusing. So explain to your buyer that you can still negotiate these items, but only during the inspection period. If there are issues unresolved, it is recommended to extend the inspection right to cancel period. That's how you go forward. So if you need more time, you extend that period, okay? Assignment of repair or treatment contracts. It's up to the buyer to decide if they want to transfer any repair and treatment contracts or warranties. I always like to ask my sellers, do you have any warranties in place or repair contracts? Termite, pest control, lawn care, pool care, water softener, appliance care, HVAC checkup, you know, do you have an extended warranty on those? If they do, the buyer say, yes, I would like all those, then the seller has to honor that request and hand that material over and help facilitate those transfers. The buyers are responsible for any costs associated to that, but it's not that the seller may or the seller should. It says the seller will. So they are obligated. Again, the terminology, the words used in the contract are very, very important. Okay, so let's wrap up today. This was a lot. We've only made it through page 6 of the contract. We still have, just at the top of page 6, we still have a long way to go. But let's wrap up what we learned today. Okay. Make sure to discuss and negotiate all closing costs prior to execution. Very important. Who's going to pay what? Okay. If the seller has a survey, they have 5 days to deliver it. The buyer has up to the title evidence deadline to survey the property, which is generally, per the contract, 15 days prior to closing. So you don't really have a big window to get your survey done. The seller is responsible for the payment of all assessments completed prior to execution, period. Okay. Once you are past the agreed upon date for flood insurance, the buyer can't back out of the contract if they don't like the rates. Very important as well. That flood insurance is so important. I also recommend use the flood insurance addendum for that, insurance addendum. We can talk about that in our addendum video we'll do down in a couple of weeks. The seller has to provide the lead-based paint disclosure as well as the energy brochure, and I should have put on there the HOA disclosure to the buyer. No exceptions. Buyers should not execute a contract without the HOA disclosure. We just talked about that, and or the seller's disclosures. They're not required. It doesn't say that they are required. They said they should not may not. Okay, very important as well. The seller has a duty to maintain the property and the grounds through closing, period. Make sure your sellers understand that. Hold it together. You got to cut, you got to cut the grass. If the grass is green at execution and 6 weeks later you go to closing and the grass is brown and dying because they didn't water it or fertilize it as they were, that's an issue. That's one of those things. Or the pool is not maintained. It hasn't been cleaned and it needs to be shocked because it needs chlorine. No. Mr. Seller, you have an obligation. The execution is the snapshot. Whatever that is at that moment, that's how the property needs to transfer. The buyer is responsible for any repairs required by the lender. I don't know how to say that more clearly than the contract says that. That blew me away. The buyer is responsible for any repairs that are required by the lender, period. Okay. Now, you can negotiate those items, and that's why you need to do it in the inspection period. Okay. But after the inspection period, you get your 4-point back. Seller, you got to pay for them. A lot of times we negotiate this, and I think because most agents don't get that part of the contract, or buyers or sellers. But legally and technically, they do. And actually, that's something that may affect us on an errors and omissions claim. A buyer or seller could state that we misstated and therefore misrepresented the contract to our clients. And that's an errors and omissions claim because we didn't advise them of that. So make sure that you are aware of that. The buyer gets a final walkthrough period. You can't be the representative, and always get it in writing that it's been done. The seller has to assist for any open permits, but does not pay any costs. Very important as well. And the buyer is responsible for any transfer of warranty costs. That's what we learned today. We learned a lot. So congratulations, you've taken yet another step to becoming an expert. It was really, really good today, and I hope that you enjoyed this. Let me kick it back off of this and stop sharing. And then we will go from there.